Good morning, Mr. Tambedou. It's good to have you with us. As you are aware, the National Assembly established this committee to look into the sales and disposal of assets of the former president by the Jammeh Commission. We've started this job way back, if you are aware, and you've been in contact with our team. Today you are appearing before the committee. What I will do now is to hand you over to the legal team for us to proceed in the testimony. Thank you. Legal.
Good afternoon, Mr. Tambedou.
Good afternoon to you.
May I say welcome back to the National Assembly. I would delve straight in to ask whether you had received a summons from this committee to produce documents.
Yes, I did receive summons to produce documents.
And in reaction to that summons, you did produce a document, or rather you did respond to that summons.
Yes, I did.
And the synopsis of your response was that you were not in possession of any documents, and perhaps we, the committee, would find solace at the Ministry of Justice.
Indeed, I did respond that the documents that were requested from me were official documents, and that the committee should refer to the Office of Records, which is the Ministry of Justice, for those documents.
Aside from the official documents, were there any other documents that could be of interest to this committee that perhaps you have not submitted?
I would have gladly shared documents if I had any in my possession that could be helpful to this committee, absolutely.
So I would begin by saying that the committee would take contention with the fact that no documents were submitted on your end. We do appreciate the fact that most of the documents you wish to refer to are official documents. The committee also notes the fact that there is a channel upon which you could approach the custodian of the documents to retrieve these official documents. See, the essence of the summons was for yourself as a witness to be able to guide the committee as much as possible. So the committee would have had good benefit of your submission of documents. And in the absence of that, the committee would be in the dark from your end. I'm sure you can appreciate that. However, aside from documents that were in the custody of the Ministry of Justice, which you have answered, and for now, I believe the committee will take your answer. And I would wish to ask whether there were other documents such as emails, email correspondences, that perhaps you could have submitted to the committee.
Indeed, there would obviously be emails, but the summons to produce documents, based on my understanding, was referring to official documents. But if it's about my personal email correspondence, certainly that could be produced. There were two email accounts. There was the official ministry account, and there was my personal email account. Indeed, sometimes I would use my personal email accounts, especially when I am out of the country. If you are referring to those sets of documents, I can certainly produce those.
So the committee would definitely want a submission of those correspondences, especially as they pertain to the issues the committee is saddled with.
If I may, what would be helpful is to seek further guidance, because I'm sure you understand it's a number of years when I was minister, and so there's a lot of correspondence by email. Unless you want all of it, it means it all needs to be printed. If you provide me with guidance as to which specific aspects of correspondence you want, I would be happy to provide those for you.
So all correspondence pertaining to issues surrounding the Jammeh Commission. Any and every correspondence.
Okay. Some of the correspondences date back from the exchanges with the Office of the President, leading to the establishment of the Commission, all the way to the disposal of the assets. You can imagine that's a lot of correspondence.
I can imagine, and I'm sure the Honorable Chair would give you enough time to be able to collect these emails. Perhaps you can, if you want to put a word in, you could put a word in to the chair, and the chair would see how best to allocate time.
Okay.
Aside from the email correspondence, perhaps the committee can take this opportunity to put to you that any documents that are in your possession, whether they are official or not, if you can submit them, the committee would be grateful.
Does that include drafts?
At this point, perhaps I could take guidance from the chair, and perhaps I could take a minute.
The reason why I ask, does that include drafts, Mr. Chair, is because the drafts went through a few exchanges before they were finalized and adopted as the official documents of the Ministry of Justice. And that's why I kept referring the committee to the Ministry of Justice as the Office of Records.
Honorable Chair.
Okay, Council. I think the final document will be okay if the committee can have that. That will be fine, because the draft, perhaps, you know, there were exchanges between the Minister of Justice and, like he said, but when they get the final draft, that will help the committee, because that's the one they have concluded on.
Thank you, Honorable
So
Chair.
the committee can have that.
Thank you. So, Mr. Tambedou, just the ones that completed, the correspondences that completed, and any documents that were fully completed and transmitted.
Just to be clear, you want me to seek those documents from the Ministry of Justice?
Well, yes. To be clear, I want you to seek the documents from anywhere you can seek from.
But the Ministry of Justice is an official ministry of the government. The National Assembly can request the ministry to provide all those documents.
The ministry has indeed provided the documents. Okay. However, your submission alone is a check on the ministry's submission.
Okay.
So
I will write to the ministry and request for the documents there.
We're grateful.
Okay.
Any other documents or any other information that you believe that the committee would be guided on? And aside from your submission, which for the record, Chair, has been marked AT, that is the witness's submission, or rather response to the has been marked AMT. And aside from that submission, Mr. Tambedou, you had the pleasure of recanting another statement with the committee's investigation team. Isn't that so?
Yes, I was interviewed. I provided my responses, which were transcribed and sent to me, and I reviewed and appended my signature accordingly.
And you just mentioned that you reviewed and agree with the content of the statement.
The signed statement, absolutely, every word in it.
Honorable Chair, the written statement by Mr. Abubakar M. Tambedou, which is headed, as I've stated, would be marked AMT 1. Thank you, Mr. Tambedou. Now, for the purposes of your testimony today, before this committee, I may ask you to cast your mind back to 2017. The events that occurred in 2017, post your appointment, with particular interest to how you would describe the overall environment in early 2017, especially after your appointment. Actually, before I get to that, perhaps I'm getting ahead of myself. I would ask you to introduce yourself formally for the committee and for the record, and give us a synopsis of your professional and academic life. And perhaps one that is of interest to me is on all the official documents, I see your name is stated as Mr. Abubakar M. Tambedou. However, you are well known as one Mr. Abubakar Ba Tambedou. Perhaps in that synopsis of your academic and professional background, you can, for my purposes, give me an explanation as to why you are so renownedly called Mr. Ba Tambedou.
Thank you, Council. My full names are Abubakar Mari Tambedou, because I was named after my paternal grandfather, who was fondly called Ba. So every other child who's named after my paternal grandfather is called, or paternal great-grandfather is called Ba. So you will find Ba Saho, Ba Tambedou, Ba Wage in our family. So that's why everybody calls me Ba. It's a nickname at home. But I see people write Abubakar Ba Tambedou as well. I don't know why, but I guess I answer to that name as well. I started my education. I'll start with high school at St. Augustine's High School. I finished in 1992 O-levels and went to sixth form. Did 1 year and then went to the UK to do a foundation in law, and then started my law degree in 1994. Graduated in 1997, then came home to work at the Ministry of Justice as a public prosecutor. So between 1997 and 2000, I worked at the Justice Ministry as a public prosecutor and state counsel. In 97 to 2000, I went into private practice here in the Gambia with a particular interest in human rights law and advocacy. Between 2000 and 2003, that's when I left the country. In 2003, I left the country. So I worked as a public prosecutor in 97, 2000, then 2000, 2003, I went to the private practice. Then from 2003 to 2012, I worked as a prosecutor at the United Nations International Criminal Tribunal for Rwanda, where I was involved in the prosecution of international crimes, including genocide, crimes against humanity, and war crimes. I was primarily responsible for the prosecution of the former Chief of Staff of the Rwandan Army at the time of the genocide, General Augustin Bizimungu, who was convicted at the end of the trial. And then I was moved to the appeals division of the International Criminal Tribunal for Rwanda in 2008, I believe, where I was also assigned the case of Mr. Colonel Theones Bagasoa, the man many believe to be the mastermind of the 1994 genocide against the Tutsis. I defended his conviction on appeal, and following that, in 2012, I was made the special assistant to the prosecutor of the UN International Residual Mechanism for Criminal Tribunals. This is a tribunal that the Security Council established and merged the International Criminal Tribunal for Yugoslavia and the International Criminal Tribunal for Rwanda as one, with a common prosecutor, a common registrar, and a common president. And I was appointed as the first special assistant to the prosecutor of that residual mechanism in 2012 until 2017, when I was offered the position of Attorney General and Minister of Justice in the country, and I resigned from the UN residual mechanism to take up my appointment here as Attorney General, which lasted until 30th June 2020.
Thank you very much, Mr. Tambedou. Perhaps at this point now I would ask you to cast your mind back to 2017 and just give the committee a synopsis and describe the overall environment in early 2017 when the government just took control.
I think that is a very pertinent question. Context is always useful, but before I respond to that specific question, perhaps, Mr. Chair, with your permission, I would like to start by expressing my own views regarding this committee. For the record, I would like to start by saying that I wholeheartedly welcome this committee. I have been a strong advocate of open, transparent, and accountable government, and I think I have demonstrated that throughout my tenure as Attorney General here in this country. And so when I saw that this committee was being established to inquire into this matter, I was quite pleased. And that's why I decided to fly into the country in person to appear before this committee and to share with the committee and the Gambian public my own views about this. And it's particularly important that this committee was set up simply because of the amount of misinformation and disinformation regarding the sale of the assets of the former president. And this, for me, is a unique opportunity to set the record straight and clear the air for a variety of reasons. Now, if this is a fault-finding process, as it appears at times, rather than a fact-finding process, which it ought to be, I can guarantee this committee that you will find flaws. And that's simply because there's no perfect process, there's no perfect system. And in a process that involves many people with many various activities, certainly there will be flaws. And I guarantee you will find. But if you're looking for evidence of improper conduct or unlawful behavior or indeed wrongdoing based on personal motives, I can also guarantee you that you will not find any. And we will see as we proceed through my testimony. I'll provide clarification. I have seen some of the evidence that was presented before the committee, not all, certainly. I haven't had the opportunity to follow all closely. But based on what I have seen so far and based on what you will hear from me in the course of my testimony, I am convinced that the committee will clear the air for the public, because that's what we are all here for in the end, the public. And so I wanted to share those with the committee before I get down to the more specific questions from Council. Now, Council, your question is quite broad. I would benefit from some specifications from you. Or specifics, yes.
Just 1 minute. Council, before he goes further, let me also make this statement. We heard you very clearly. First of all, let me also say the committee appreciates the fact that you willingly travel by yourself to come to the Gambia and testify before this committee. That shows that you respect the establishment of the committee and the work that we are doing as well. But also tell you, this committee is also very much aware of its mandate, and we want to ensure that we find facts. And that is the ultimate intention of the committee as well. All that we are doing is to ensure that facts are found, and then we report what is facts. That is exactly what we will be doing. And we definitely appreciate your coming, and then we will continue doing that until at the time that we will be reporting back to plenary from this very important job. Thank you so very much.
Okay. Thank you, Mr. Chair. Council, your question is very broad. You want me to cast my mind back to 2017?
Yes, Mr. Tambedou, I do. Of course, every question that I ask you is in relation to the Commission. So while you are casting your mind back to 2017, I do note that you were appointed in February of that year. What is of interest to the committee are the moments leading up to the setting up of the Commission.
Of the Jammeh Commission, if you like.
Indeed.
By the way, that title came from me, the Jammeh Commission.
I see.
Well, these were very early days after the change. It was a very, I'm not sure whether I can describe fully at one go everything that was going on in the country at that time, but suffice it to say that it was a very chaotic period, not just for the government, but for the country as a whole. I believe I was one of the last ministers who were sworn in. I was sworn in February after my appointment, when I briefly came to the country to meet with His Excellency the President at the time. And I don't recall participating in any cabinet meeting during that first period. So I had to go back and pack up my stuff to come back home finally. And I believe that occurred around March or so. But when I came back anyway, we started holding our cabinet meetings. And there was a lot of political pressure and tension at the time in the country. The new government came under tremendous public pressure to be seen to be doing something about the former president and his associates. And so at the time, cabinet discussed and decided that the first thing we should do, because I believe, I don't want to say politicians because I'm sitting in a room full of politicians, but there was pressure on the politicians in cabinet from their supporters, etc., who were seeing the businesses of the former president continuing as usual. They were seeing the businesses like the bakeries on Caraba Avenue still open and being run by associates of the former president. They were seeing cars of companies belonging to the former president roaming around. And I think the pressure was too much for the politicians in government, and in turn they wanted to be seen to be taking action to stop those. And I believe there was value in that as well, because all of those visuals that people were seeing around were reinforcing and reminding people of the atmosphere of repression that obtained in the country up till that moment. And so it was normal for people to react in that way. Some were very angry. I recall being accosted by someone and telling me why we were not doing anything about the activities of companies and people associated with the former president, including the abattoir as well. In fact, I recall late Oye Jallo came to my office with some people who work at the abattoir, and again the pressure was on. The abattoir was still being run by the associates of former president, etc. But anyway, to summarize what I'm saying, there was a lot of political pressure for the government to be seen, to be doing something, and then the idea of freezing the assets of the former president was floated in cabinet. I recall we had exchanges amongst.
Sorry, this was when you came back.
This was when I came back in March. Yeah,
and settled in finally in office.
And settled in finally, yes.
Please proceed.
It was a cabinet room with 3 lawyers. Honorable Hussein Dabo was a lawyer, Honorable Maifati was a lawyer, and I was a lawyer. And you can imagine a room with 3 lawyers. We dominated the discussions on the way forward, what to do, etc. And I was instructed by cabinet to freeze the assets of the former president. How best to do that was left to me as Attorney General. And so that decision was made in cabinet through a cabinet resolution. In fact, it took some time before I submitted ultimately the application to freeze the assets, because I'll tell you my own views about governance. I came in as Attorney General with a concept of how a new Gambia, a new government should be run. And that is what informed every activity and action that I led at the ministry at the time. And so I was put under a lot of pressure to freeze the assets. I resisted that pressure because I wanted them to provide me with something I can go to court with. I thought that this was a new environment. The judges were going to be more assertive of their independence and impartiality, and that what obtained in the past under the former regime was not going to work anymore. And in any event, I was not prepared to go to court without a prima facie evidence on my hand. And that is why it took time between my appointment and the freezing application in May, because I wanted...
so somebody, perhaps if you would decode prima facie for the committee, okay, and for the record as well.
I wanted some evidence to go to court with. We didn't want to go to court and apply to freeze the order without anything to back it up with. And so I insisted that I wouldn't go to court without that. And various suggestions were made to go through the civil law procedure, etc. But for me, it was more than just freezing the assets. For me, it was going to be a statement that this country was going to change. It was no longer going to be business as usual, that it was going to be based on law. And so I insisted.
My apologies. Who were you having this discussion with?
In cabinet.
In cabinet, okay.
Yes, in cabinet. Everyone knew my position. All right. I wanted, in particular, the Ministry of Finance to provide me with evidence that I could use to go to court. And that was not forthcoming as quickly as I would have liked. Notwithstanding the pressure, I still didn't want to go to court.
And who was the minister at that time? The Minister of Finance?
Honorable Amadou Sane. So between February, March, April, May, ultimately, I received something. It was the late Secretary General Fadera who called me in the evening when I was already home and told me that he has obtained information from the Financial Intelligence Unit about the financial transactions of the former president, which I could look at and see whether that would be helpful. So I actually recall to this day, that was the first and only time I visited late Fadera's residence. I believe in Bruford. I had to drive there myself at night to go and pick it up because I was also under pressure to do something. I didn't want to wait until the morning, then it is sent. Sometimes government communications takes time. So I drove myself at night to Fadera's house, got the information from him, went home, looked at it briefly, and then the next morning I called my team to a meeting for us to take a look.
If I can just, if you could hold on there. The document you're referring to, it's a document, a report from the Financial Intelligence Unit.
Yes, it's a report. If I recall correctly, it was certainly bank accounts. It was a statement of accounts with transactions listed. And I believe it was on the cover of a report. I can't recall now exactly, But it certainly provided us with the smoking gun we needed. Because when we looked at the document at the ministry, we realized that some of the activities could be classified as money laundering activities. So that's when we started thinking about how to make the application for the freezing order.
So just on that point, and we will definitely get into the freezing order much later, but on that point, the document from FIU, was it ever submitted officially to the Ministry of Justice?
Well, that was the official submission. I had to pick it up myself.
Okay.
I had to pick it up myself. If you have a document, show it to me. Maybe it will refresh my memory about that.
That's precisely why I asked whether it was officially sent to the Ministry of Justice.
It was still official. It was handed over to me by the Secretary General in the President's office. Official is not only restricted to written communication.
Well, my perception of official is something that is on record.
Yeah, well,
And this was a submission that was, if I may say, informal. I do not want to use clandestine,
okay.
rather informal. But still a submission nonetheless. And that's precisely why a summons was issued to you, because if that document was not officially sent to the MOJ, they would not have it on their record to make it available for us. And thereby, the committee would excuse the MOJ from not submitting that. However, you had received the document yourself. Of course, I'm sure your Solicitor General would have seen it at some point. However, it should have passed through him for official transmission of the document. Now, I'm interested in this point because that document will be of interest to the committee. If you can facilitate, Honorable Chair, if I can ask that the witness provide that document to the committee, the report from FIU.
You know, Counsel, you were right when you say it was informal, but it was nevertheless, as I said, official, because it was from one state, senior state official to another. These were extraordinary times, as I said. There was chaos. I mean, if I wanted to wait for the official channels, so that means the Secretary General, or rather the FIU, would have written their report, send it to the Ministry of Finance in the official channel. The Ministry of Finance would then send it to the Office of the President, and the Office of the President would treat it. It will go through the communications procedures internally, then gets to the Secretary General, and then the Secretary General or his office would then write to solicit. It was going to take time, and so that's why I had to, because you need to appreciate the pressure under which the government was at that time to take quick action. But anyway, that document was the basis, formed the basis of our application for the freezing order. So I am surprised that you couldn't find it. I'm not sure if you had requested it from the ministry, but I'll be very surprised if it's not there, because my team and I worked on that document at the time, including the Solicitor General and others from the Civil Litigation Department. But in any event, we received this document, and we now had our smoking gun. We now had some evidence to use to freeze the assets.
All right, before we go to the assets, let's still linger around your time when you just assumed office. With regards to the assets, what were the immediate concerns that arose regarding assets at the time of the transition?
You want me to be honest?
Please.
It was not high on my priority list. We were dealing with more fundamental issues of governance. We wanted to change the political trajectory of this country, because that was what that moment was all about in 2016 December. So the assets were not high on my priority list, to be honest. I had more, I wouldn't say more important things, but I had equally or perhaps more pressing issues of governance to deal with. You would be surprised if I give you a rundown of the list of issues we had to deal with between 2017 and 2019 alone. Just that 2-year window. It was incredible. Yes, at the time, to be honest, the assets were not high on my priority list. My ministry was focusing on more fundamental issues of governance at that time. We, at the time, knew that the local government elections were coming. We wanted to change the laws to facilitate more direct participation, etc. So those were all issues that we were dealing with. There was just chaos, as I said, in government and outside government. We were overwhelmed, not just at my ministry, but the entire government, I believe. And so you can imagine in situations like that with less resources at the ministry, I wasn't going to give the assets a high priority on my list.
All right, that's understood. However, I still would like to know, with regards to the assets, what were the particular concerns the government had before you received any reports?
Well, I believe I did say that there was political pressure from supporters of the politicians in cabinet because they continue to see the symbols, signs, vestiges of repression on a daily basis. It was as if nothing had changed in the country at that time. It was as if business as usual. It was business as usual because the activities of the former president, insofar as his companies and his close associates were concerned, were still going on. And I believe people were not amused about that. And so the government wanted, as I said, to be seen, to be taking action on those assets, because that meant removing from the public eye these reminders of the repressive state that was prevalent in the country at the time. But that was the, I believe, primary motivation of the government. But they were also receiving reports that the assets were being dissipated as well. There were reports that cattle were being stolen and taken to Senegal. There were reports that some of the assets were idling around. Vehicles, motor vehicles were discovered somewhere in Casamance, I believe. So there was also this concern that the assets were being dissipated. So the government also wanted to preserve those assets. And I think that was perhaps the second motivation for the government's desire to take action on the assets.
You speak of reports. Where did these reports emanate from?
From the public. People will hear. Colleagues would tell me, this is what's happening, that's what's happening. Just generally.
So they were not necessarily documented reports?
At that time, no one had time for documented reports of incidents like that early 2017. Were you in the country?
I wasn't, but
okay.
I'm happy that I'm not the witness today.
Lucky you.
Yes. Well, the reason I ask what reports, Mr. Tambedou, and I would just segue for a bit, but come back to 2017. Since I wasn't here, I want a very apt depiction of the atmosphere at the time. But my segue will take you to MOJ2, Chair. MOJ2 is the legal notice that established the committee. Now, the commission rather. Now, the first paragraph of that legal notice, if the Secretariat could provide the witness with a copy. So I believe it's before you.
Okay.
Please read aloud perhaps the first sentence. I believe it's one sentence, the entire paragraph, but read until perhaps where there's a listing of institutions.
It's the preamble, right?
Yes.
Okay. Whereas preliminary reports received from, among other things, the Central Bank of the Gambia, Social Security and Housing Finance Corporation, Gambia Ports Authority, Gambia Telecommunications Company Limited, National Electricity Company Limited.
That's fine. I would not burden you to go through the entire list. My point, the point I'm trying to underscore here is that the legal notice itself references preliminary reports from several institutions, which it goes on to list. Are these the reports that you are referring to when you mention that reports came from several institutions?
Through the FIU report that was shared with us, yes, the financial intelligence report clearly showed transactions from all these institutions with the former president, certainly.
So essentially, the first paragraph of the preamble is referencing that document from FIU?
Including that document, yes. Including that document.
So that document and all the MOMAs around town?
They were not MOMAs, they were reports.
I see.
They were not written reports.
Okay.
I don't think Gambians are fond of written reports. The public would call, they would go see officials and tell them XYZ. Officials from those institutions will share their own experiences.
These were reports from officials?
Including officials, yes.
All right.
Officials, ordinary citizens, the documents from the financial unit, all of that together. Yeah.
I'm still interested in how the reports, other than the FIU report, were received. Now, you did say they were verbal reports. But how were they received? Was it that they came to the Ministry of Justice to inform you, or was it just casual conversations with acquaintances? How did they come about?
I tell you how I received the reports. I don't know how others received the reports, but I received the reports from one, the document from the Financial Intelligence Unit, and two, from my colleagues in cabinet. Don't forget that all of these institutions have line ministries, so the ministers would share with me information as part of the discussions about what action the government should take against the former president at that moment. So they were sharing their own reports, albeit, as I said, not written reports, but the report of the FIU alone provided us with sufficient basis to take action.
Yes, I'm curious in the manner in which the reports came about, because I would like to know whether, as they came verbally, did you metamorphose them into written instructions or information?
It was in the context of cabinet discussions, and there are minutes of cabinet meetings. They might have been captured in those minutes, but it was in the context of discussions in cabinet.
So, okay, so for the record, let's say it was the FIU report and the discussions amongst the different ministers or ministries in cabinet.
Yes, which form part of the report referenced in the preamble to the legal notice. But as far as I was concerned in my ministry, it was the report of the FIU that made the difference.
Very well. How did the government first identify which assets to investigate or to preserve? In fact, how did the government first identify assets?
That's why we froze all the assets. There was no identification of which assets to, there's no process of identifying the assets. We froze all the assets because, one, we didn't have the resources to even venture into something like that. We had no idea what the scale of these assets were. I certainly didn't. And so out of the abundance of caution, you freeze all the assets, and that's what we did.
Now you say you freeze all the assets, and my question is, how did you come about gathering all the assets?
As in, how did we get information about the
how
assets?
did you identify those assets?
Okay. For the bank accounts, the Financial Intelligence Unit provided us with the bank accounts. For the landed properties, the Ministry of Lands provided us with a list of properties that purportedly belong to the former president. In terms of the motor vehicles, as far as I was concerned, because I recall having been consulted by late Secretary General Fadera about the motor vehicles which were found at State House, I think, as in all authoritarian systems, there is a thin line between the head of that authoritarian system and the state. I'm not sure if you're familiar with the phrase "l'état c'est moi." That is common in dictatorships. And so it's difficult to draw the line between what was personal and what was national. So late Secretary General Fadera did once consult me on the vehicles that were found at State House. I think Finance wanted to do something with the vehicles. I can't remember now exactly. I'm growing older, as you can see, so my memory is failing me. And I recall giving him advice at that time over the phone that any vehicle that were found on state property are to be presumed to belong to the state until the contrary is proved. So if anybody has a claim over those vehicles, it's up to them to come and state that claim. But the default position for the government is to make the assumption, it was rebuttable, of course, as I said, based on evidence, but to make the assumption that they are state property. And so the finance ministry and the government could do what they wanted with those vehicles, because as far as I was concerned, they were found on state property, they belong to the state. So these are the three categories of assets, I believe, that we discussed at that time. So the landed properties, the cattle, and the motor vehicles.
Okay, we will get to the assets a bit later. You have mentioned that public concern or public consideration was top amongst the list as to how and why the government acted the way it did in 2017.
As far as my political colleagues were concerned, yes,
yes.
Not me, okay, personally.
What about the international community, international partners? Did they play a role in how fast the government acted?
At that point, I think I was at the same wavelength with members of the international community, both in and outside the country. Our preoccupation at that time, the most pressing issue, was governance. How do we ensure that there is peace and stability in this country following the forced departure of the former president? It was a very fragile moment for our country. It was a very volatile moment, and our preoccupation was ensuring that there was stability and peace, and not just peace, sustainable peace. And you can imagine in that context, assets wouldn't be the priority of members of the international community in this country as well. So I was on the same wavelength with them.
All right, thank you. You had mentioned or made reference to your political colleagues. please clarify for the committee who you're referring to when you say
The politicians who were in cabinet.
the
There
ministers.
were a number of them, yes.
All right.
Ministers.
So that the members of cabinet then.
Yes, indeed.
Okay. I'm also curious to know how the government balanced the need for speed vis-a-vis the need for accuracy and ensuring fairness in the asset investigation. That is prior to commencement of the
speed and fairness. When you say fairness, what do you mean exactly?
To ensure that there are procedures and protocols put in place to ensure that the whole process of investigation is transparent.
Counsel, since you were not in this country, let me help you a little bit more.
Thank you very much. I would really appreciate that.
We were witnessing for the first time in our history here a change of government, at least in my generation, a change of government that ultimately led this country on the verge of violent conflict. Gambians were leaving these shores to find refuge in neighboring countries. That's how tense the situation was at that time. We were getting ready to see on Gambian soil foreign soldiers who were coming in to preserve the peace and make sure that there was a handover of power of some form, whether by force or by peaceful means. And that's what I meant when I said it was a chaotic time early on. Maybe I need to be more explicit now so that there is clarity.
Please do.
We were just recovering from the verge of a violent conflict. And the government's priorities was not to secure the assets of the president. Our priority was to ensure that despite all the factors that could lead to conflict were present in this country, we were doing our utmost to ensure that there was peace and that there was a smooth transition, both within the armed and security services, because we were receiving the reports. I was receiving the intelligence reports at that time. And even amongst ordinary citizens.
Are we speaking of the same reports? You had mentioned intelligence.
No, these were reports about this general security situation in the country, including within the armed forces. Even amongst the local population, amongst communities, there was apprehension, there was fear of reprisals and retaliation. And we were doing all we can to manage that situation. The unfortunate death of Haruna Jatta in Kanilai was not an isolated incident. It was unfortunate, but it was not an isolated incident. But it also illustrated the tension, the visible tension that was in the country at that time. The Faraba Banta situation, which led unfortunately to some deaths, was another illustration of the tension that was in the country amongst communities, etc. So that's why I said the assets of the former president to me were not high on my priority list. I had more pressing governance matters to deal with to ensure that we could even do anything about those assets, because without the right environment at that time, you can't do much. So our priority was ensuring that the environment was conducive to building upon our democracy. So whether we did anything to make sure that the preservation of the assets was fair, etc., we did the best we could under the circumstances. We identified the assets in these three categories. and we submitted our application to the court for a freezing order, freezing all of those assets as appropriate.
Yes, like I said, we'll get to that. My concern here is, were there measures put in place prior to going to investigation?
Help me here. When you say measures prior to investigation, what do you mean? Because the investigation, there was a preliminary report based on which we went to court to seek the freezing order, and then the investigations developed after that. So what period are you talking about?
So once the government was properly seated.
Properly?
Yes.
I'll qualify that.
Once the government was seated, or perhaps I would maintain once the government was properly seated and the reports came in, now these reports would have to be substantiated, and that would warrant for an exercise to ensue. And that exercise is what I'm referring to as the investigations.
They didn't need at that point to be necessarily substantiated. We had enough substantiation to go to court with. That was the starting point. If you have reasonable basis to take action, you can take action, and then you can investigate further. If I were to give an analogy, is if a police suspects you of committing a crime and they think that you're a flight risk, they will arrest you, and you go to court, you request for bail. They will, when they oppose bail on the basis of additional investigations, that's because what they have at that point, up to that point, was preliminary evidence to arrest you. Now they need to build upon that evidence by conducting investigations. And the reason they would usually oppose bail is so that there is no interference in that additional investigation. So that's exactly the situation here. We had enough evidence in our hands, which I demanded. Before that, we didn't have any. That's why I didn't go to court between February, March, April, until May. But when we had the Financial Investigations Unit share their reports with us, we used that as a basis to first seek the freezing order and then start investigations as a result of that report. So the investigations came after we received the preliminary report from the FIU.
And those investigations were to verify the information that was in that report?
Including to verify the information that was in that report, including. It was not just limited to
yes.
that.
So you see, my question relates to how you went about that investigation, what measures you put in place to ensure that the process is seen to be transparent. You see, just like the analogy you just provided, just like the accused person would be remanded for further investigation, you see, the prosecutor would know that it's his liberty that he's playing with, and I'm sure the court would perhaps not playing with, but you know, his liberty at stake. And the court would have that in mind as well, and the court would ensure that it binds the investigators, the prosecutors, to a time limit, so as not to cause an infraction on the accused person's liberty. In the same vein, the investigations, your testimony here today, you have attested to the fact that in 2017, the environment was chaotic. And perhaps if I can add salt to the wound to say that the environment was not only chaotic because of the regime that you took over from, but also there were proponents from that regime that were demanding a fair, to be dealt with fairly by the government. Now, with that in mind, what measures did the government put in place? Now, when I say the government, this would be the MOJ, which you were the head of. At this time, it was limited to the MOJ, I presume. Correct?
I am not very clear about your question in terms of...
So I'm giving you context to the question.
No, I get the context.
You get the context, okay. Please go ahead.
Yeah, because the witness kept referring to FIU as the Financial Investigation Unit, And I think it should be the Financial Intelligence Unit if we can correct that.
Sure.
If I said investigation, then I misspoke. You're absolutely right. It's Financial Intelligence Unit. Yeah.
Right. So the government would have had in mind that there's a lot at stake. The government needs to recover all the assets that were modeled in as part of state assets or not, and decipher between the two. And that exercise alone should have warranted some caution with the government to be able to decipher what is what. And that's what I'm referring to. When your team or whoever did the investigations, when they were going out to do investigations, did they, before they went out to do investigations rather, did you put any measures in place to ensure that everybody's in the picture? There are measures in place to ensure that from a third party's point of view, the process is as it should. I hope that helps.
Again, I am a little bit lost. There was certainly a lot at stake, but there was more at stake about the peace and tranquility of this country. And that's why our focus was on governance, as I said, and not the assets, because the properties weren't going to go anywhere. The landed properties in this country, the vehicles are on state property. Some of the cattle have been discovered. There are reports that others have been stolen, etc. But to be honest, if I had to deal with security sector reform or the establishment of a truth commission, the transitional justice process, I mean, the assets recovery was also part of it, certainly. But I had to prioritize, especially given the resources available at the ministry. So again, the assets were important, but there were more pressing matters to deal with at that time. Now, in terms of the investigations, that's where I am a little bit at a loss. I don't know exactly what you mean, but the establishment of the Jammeh Commission was part of that investigative process. That's why we established the Jammeh Commission to also investigate. We also reached out to our Senegalese colleagues across the border to find out about the cattle that were being moved across the border and some of the vehicles that were being shipped across the border. So those are some of the activities that the investigators were engaging.
All right. I'm tempted to ask the question again in a different way. However, we can proceed. It will come up again. Were there any disagreements within government, when I say government, perhaps cabinet, as to what approach to take in the asset recovery? You had mentioned that there were 3 lawyers.
Yeah, there were no disagreements. Ideas were just being proposed on the best way forward, all of which I took into account when we were making our final decision at the ministry. So there was no disagreement. I think we were all agreed in principle to take action. How best to take that action is what we were discussing, and ideas were put forward, and for my consideration as the Attorney General.
Now, I can appreciate that the ideas were put forward, and perhaps the idea of a commission was the idea that was then heeded to. However,
the idea of the commission came after. We're now at the assets freezing stage. Or did I confuse your question? Because the discussions in cabinet and the ideas that were being proposed was how best to take interim measures while we consider what comes next. So the decision to set up the commission came after.
Came after, I see.
But as a first step, we wanted to secure and preserve the assets.
At that time, the mind of the government was on preservation.
Indeed. As a first step.
I see. All right, going back to investigation, I presume there was investigation of some sort. Let me call it preliminary investigation, because you have rightly mentioned the commission was part of that investigation. So the preliminary investigation, and then you proceeded to court.
Yes, we used the information from the FIU mostly to seek the court orders.
So, did the atmosphere at the time of the transition make it difficult to coordinate amongst your peers, in the other ministries?
The atmosphere made everything difficult at that time, not just to communicate with other ministries. It was a very difficult situation, let me put it that way. You know, one of the legacies of dictatorship, I'm sorry I have to keep providing that context so you can better appreciate the environment at the time. One of the
that all persons would be treated fairly and the process would ensue in a very transparent manner. Were there any such mechanisms?
Well, I can tell you that the former president, whose assets were being preserved at that time, was treated with as much fairness as we could have provided under the circumstances. I.e., that is to say, the assets were frozen to ensure that nobody dissipated them. Before the freezing order, as I said, we had reports that some of his cattle were being stolen. These were private property. It was up to the former president to secure his assets. The government only intervened because of the repeated reports about these assets being dissipated, and also for other considerations. As I keep saying, I don't want to repeat myself again. But what action did we do to ensure fairness? That's the part that I am still not following you on, because the freezing of the assets was exactly to make sure that the assets are secured until a determination is made as to how those assets will be dealt with. That's what we did. There was a request to freeze those assets and place those assets in different government departments, at least those with expertise to deal with the different assets, if you like, and that's what we did. I'm not sure when you say there were a fraction of the population or proponents of the former president who wanted to be treated, who wanted fairness. I mean, they were not affected. These were the assets of the former president, and if
and his affiliates, right?
Up to this point, yes, and a few of his affiliates, certainly.
And most of the businesses, in fact, were companies.
Indeed, companies that, based on our records, belong to the former president. Absolutely.
Yes, but you and I especially would know that a company cannot entirely belong to him. Perhaps in practical terms, I do understand where you come from, but the company is a convergence.
Yes.
I would agree.
And that's why we entrusted those companies to a receivership.
And it is those third parties that I'm referring to when I talk about fairness and transparency.
Oh, no, we were very, very fair. You see, whenever I try to get into the freezing order, you tell me we will come back to that. But you will see when we get into the freezing order proper that we were treating everyone with fairness. I have personally received requests, and I can share that with you now if it's a convenient point for you.
Please
But what we did was we adopted a default position because we didn't have the resources to devote to that process of going through each asset to make sure that third parties were not necessarily affected. We tried to minimize the risk of collateral damage on third parties, certainly. And that is why, for example, when we froze the assets and the Jammeh Foundation Hospital came to us and said, this is a government hospital. The bank accounts that you have frozen do not belong to former President Jammeh, they belong to the government. It is just the hospital that was called Jammeh Foundation Hospital. We immediately requested for a variation of the freezing order so that the bank accounts that belong to the Jammeh Foundation Hospital would be released. Another example, the current Deputy Speaker requested an audience to see me, Honorable Sidi Jai, because the APRC political party bank accounts were frozen, and in fact he was supposed to come with the speaker, but then he ended up coming alone, and just to demonstrate my openness at the time to meet with everyone irrespective of their political orientation. I was there for everyone, not just for a particular section. So I received him in my office, and he came to ask that we unfreeze the APRC bank accounts because the bank accounts were not Jammeh's, they were the parties, and it was monies in the accounts were the result of contributions from individual members of the party. And he will tell you that I told him I am in principle open to unfreezing the APRC bank accounts if he can bring evidence to me to show that these were indeed the contributions of individual members of the party. That was what I told him. And I was going to do that if he had demonstrated at that point that the APRC accounts were the result of individual contributions from party members. He never came back or produced that evidence, and so the account remained frozen, just to illustrate that we were open to dealing with people fairly. So what we did, we took a default position and froze all, and then on a case-by-case basis, when people make claims that we thought were meritorious, then we reacted to those claims. So that's what we did to ensure fairness.
Okay, I will get back to the assets again. however, would like to know the assets investigation prior to going to approaching the High Court. Did the government see it as part of rebuilding trust in state institutions after the former regime had taken off?
I wouldn't want to claim the role of spokesmanship for the government, because when you say did the government, you're now making it a little bit more fluid. Let me tell you what I and my ministry did, what we were thinking about when making those decisions and taking those actions.
Sure. You can do that. However, we would also like to establish one thing: the ministry is not acting in isolation.
Absolutely.
It
Absolutely.
acts on behalf of the government. So whatever actions the ministry takes is part of the government.
In fact, to even go further, every action that the ministry took at that time was based on a government policy decision.
Precisely, and that's why when I refer to government, I believe since the ministry was saddled with most of the affairs surrounding the commissions, and particularly this commission, it would be fair to say that you could speak on the mind of the government at the time.
If that's the approach you want to take, I don't have a problem with that. I can live with that.
Thank
so, if you don't mind, please repeat that question again, the last one you asked.
Did you see the assets investigation as part of a rebuilding state trust in state institutions after the former regime?
I keep repeating myself. As at that time, the processes that we thought would engender trust in the reform processes that we were going to embark upon did not include the assets. The assets, again, were not an issue of governance. The assets are not high on the priority list of the government because we were embarking on a transitional justice process with little resources at that time. And so our priority was to devote those little resources to the most urgent and most pressing matters of state, particularly governance, because the whole idea of the change of government to change the governance architecture. And we didn't take our eye off that ball. And that's our focus, to be honest, was on those issues rather than the issue of the assets at that time. If you are allocated few resources or fewer resources, you have to prioritize your activities. And that's what we did at that time, and the assets were not high on our priority list. So the issue of engendering trust wouldn't even arise insofar as the assets were concerned, because we wanted to engender trust for the more pressing matters of governance. And I can elaborate on some of these activities if you want.
That's fine. I believe you have alluded to them, the security reforms and
There's a whole host of them.
the TRRC, etc.
The CRC, you know, quite a lot.
Yes. But for some strange reason, despite all those pressing issues, this was the first initiative of your ministry.
It was the first major activity in our transitional justice process.
Yes, indeed.
Absolutely.
So how do we reconcile that?
It was a low-hanging fruit.
Nice.
When you have a whole host of activities to do, notwithstanding the fact that an activity may not be high on your priority list, but if it's a low-hanging fruit, if it's something you can set up very quickly and get it out of your way while you focus on other things, you do that. You do that, and that's what we did in the case of the commission.
Now that's interesting. It was a low-hanging fruit. However, your testimony here also alludes to perhaps the unpreparedness, for lack of a better word. I'll give you a minute. My apologies.
Go ahead.
My co-counsel says I must say sorry to you. All right. Are you much better?
No, go ahead. I'm fine.
All right, that's fine. It was not a priority. However, it was a low-hanging fruit. And you have alluded to in your testimony the fact that it was something you were not too prepared for. Would I be right in making such a statement?
Too prepared for. It was something that we did to the best of our ability, given the resources that we had at that time.
You know, we had a witness here the other day that said, everybody is wiser in hindsight.
You can say that again.
And I would like to ask, in hindsight, do you believe the ministry was ready or the government was ready to undertake this task?
If you were to give us the environment, the same environment today as we had at that time, I have to say we even exceeded expectations given the challenges that we had. Now, in today's Gambia, where things seem pretty settled, if you gave me that task, I would do it differently. There's always room for improvement. There's always lessons to be learned. And I believe I said this 5 years ago in my farewell statement, that in hindsight, certain things could have been done differently. There was always room for improvement. So that is just the nature of human beings. It's good to have self-reflection and to admit that no system is perfect, that there's always room for improvement. So if I were to do it today in this environment, I would do it differently. You would have a much improved version of events. But if you were to transpose that same environment today, I would do exactly what we did then, because that was what we had at that time.
Fair enough. Let's go back to the FIU report and the other reports. Were these reports, pardon me, you had mentioned that the reports were discussed in cabinet.
The report was handed over to me by the late Secretary General, and I took it to my office and had a meeting with my team, and then instructed the Civil Litigation Department to prepare the applications based on that report. Yes. I'm not sure if the reports were discussed in cabinet, but I did make requests for information that I could use to go to court in cabinet. Those were discussed in cabinet.
So it was understood from your proceedings in cabinet that information would follow on and you would act upon that information.
I was very clear. It was very clear, and in fact, I recall there was a cabinet meeting when I was asked, after a few weeks of nothing happening, I was asked why I wasn't doing anything about the assets, and I said I haven't received any information yet. And I believe the President intervened and requested the Minister of Finance to help me get that information. So just to say that everybody knew that I wasn't going to go to court empty-handed. I wanted something, and if they were not going to produce that thing, I was not going to court.
All right. All right. I would like to cast your mind back to that preparation to go to court. But before that, were there any meetings after you received the report from FIU and the various other reports, but before you proceeded to file the suits in the High Court?
Any meetings where?
Anywhere.
Within my ministry?
Within your ministry, in cabinet, with stakeholders?
No, at that point, there were fewer meetings in cabinet on this issue. So it was a question of implementation now. And so obviously I had meetings with my senior management. I recall certainly having a meeting with the former Solicitor General and some members of the Civil Litigation Department, because when I received the information, I summoned this meeting at the ministry I was the one who personally raised the issue of the implications of a freezing order, i.e., I wanted to avoid as much collateral damage as possible. There were ordinary citizens who were working in these companies that the former president owned, who were earning a living from these companies. And if we were to impose a blanket freeze on these companies and their assets, all of those people will be out of work, and the businesses will be shut, and that's the end of the story until a determination is made subsequently as to what to do. So, in consideration of those people, I told my team to see how best we can freeze these assets and then entrust these companies, a sector, to a third party who will continue the business and allow these people to continue their work while the government decides what to do subsequently. And the civil litigation came back to me with a proposal. They came up with the Anti-Money Laundering Act and said there is provision here which allows us to freeze the assets and to entrust the assets to a receivership, so that the receiver will act as interim caretaker over the assets, continue to run the businesses, people will not lose their jobs, while the assets will also not be dissipated. Because the whole idea of applying under the Anti-Money Laundering Act is to prevent assets being dissipated by the subject of investigations. And so it was that we agreed to use the Anti-Money Laundering Act and submitted our application to freeze all the assets.
Right. I can sense that you're eager to speak about the High Court orders. However, before we get there, the committee has received evidence that a meeting was held at the MOJ with stakeholders prior to the suit being filed. And some of these stakeholders would be personnel from the offices of Augustus Prom, the chartered accountants, and some other personnel, including the registrar of companies at the time, and the registrar general as well, to prepare for what is to come, what is about to come. Can you confirm such a meeting?
That one is a difficult one for me, because first, as Attorney General, I'm only responsible for policy, not implementation of that policy, so I wouldn't know much about the operational details. But two, also because when we were making the decision to freeze the assets, there had to be an element of surprise in that decision. It's like a police going to do a dawn raid. They don't inform the suspect that they were coming to conduct a raid.
Of course.
So it was a similar situation. We were about to freeze the assets. But if we let that information out, there are people who would take advantage of that situation and try to dissipate some of these assets. In fact, to give you an example, soon after when I announced the freezing of the assets in a press conference, a senior counsel called me to say, and this is before we actually wrote to the different banks, wrote to me and said, a bank has called her, because she was counsel to the bank, and said there were attempts to withdraw money from one of the accounts that we had identified. But luckily, the senior counsel was experienced enough to advise the bank not to allow that, because even though we have not yet written to the bank and officially notified them, my press conference served as constructive notice to the bank. And so they couldn't ignore that. Just to say, to basically relate it to the fact that I would have been very surprised if a meeting was held before with all the stakeholders because of the risk of dissipation of the assets. So it had to be a very small group who knew of our decision to freeze the assets. Certainly, we had meeting with Augustus Pom because I was actually involved in that part as well. So we can come back to that. But in terms of the wider stakeholder group who were to implement the order, I wouldn't have thought so, but it's possible.
All right, so there was a meeting, but it was a very small meeting. So
yeah, myself, maybe 2 or 3 members of the civil litigation department.
What about the Registrar General?
I do not recall the Registrar General being in that meeting. I do not recall that.
But Augustus Pom was in that meeting.
Augustus Pom came to see me after, because there were 2 meetings. They met with Augustus Pom separately, and then, or maybe after my meeting with Augustus Pom, but certainly Augustus Pom did come to see me because I was the one who asked my civil litigation department to contact Augustus Pom for me and invited them to a meeting in my office.
Now, the evidence the committee received from 2 witnesses, the first being the Registrar General at the time, places you in a meeting. Of course, I do agree with you that your portfolio is policy. However, from what the committee received, that was a policy briefing meeting to equip them in their implementation once an order was sought and granted. Does that refresh your mind?
I wouldn't rule it out. Like I said, it was a small group because we didn't want the information to go out. So if the Registrar General, who was going to be one of the people who was going to be given a responsibility in that order that we were seeking from the High Court, it makes sense that he would be in that meeting. I cannot recall. Who was the Registrar General at the time? Aliou Jallow?
Yes.
Aliou Jallow. It's possible I will not rule out the fact that he would have been in that meeting. But because you mentioned other stakeholders, I was thinking about the operational meeting that he held with third parties outside the ministry.
Yes,
but,
he mentioned 2 meetings.
Yeah, but in terms of the ministry, it's very possible that he was there as well as Registrar General. I will not rule that out.
Okay, so a meeting was held to discuss the policy issues that perhaps may arise from the entire activity that you were about to take part in.
Mm-hmm.
You received reports. Those meetings were held. Can you take it from there?
A decision was made to apply to freeze the assets. As I said, in consideration of those who were still employed in these companies, we...
So, perhaps, if I may guide, prior to instituting the suit and approaching the court on an application, were there any other activities, perhaps, that may be of guidance to this committee?
Activities such as?
I would want to know anything to prepare for the suit.
Well, yes, there were meetings, certainly. I think there were a couple of meetings. The final meeting perhaps would have been this meeting where the former Registrar General said he attended to make sure that those who were going to play a key role in the process were informed beforehand. But there were meetings prior to that. For example, there was a meeting to decide who in government, which government department was going to be entrusted with the different kinds of assets. For instance, the cattle. We thought it was best to entrust the cattle to the Gambia Livestock Marketing Board or agency. I can't remember now. So they were identified as the appropriate government department to take care of the cattle. The wildlife, the crocodiles, the hyenas in Kanilai, we identified the Department of Wildlife to take over. those wildlife. And who else? Well, we had Augustus Prom, who was to take over the companies as receiver, and then the Registrar General as well. So we had identified strategically, because a lot of thinking went into this. As I said, we didn't just want to get up and go to the court and freeze the assets and then realize the ministry doesn't have the expertise to deal with cattle or wildlife sector. That's why we considered all of these different government departments and entrusted responsibility to them. At the time, I understand there was reluctance after the order, because some of them complained that they didn't have the capacity.
All right. Before we get to the order, I know I keep teasing you with the order, and I promise you we'll get there, Mr. Tambedou.
No, it's okay.
I'm interested in those meetings and the result of those meetings, because you have rightfully mentioned that before approaching the court, you needed to put your ducks in a row and ensure that all the properties were in proper custody once the order was granted. Now, the decision was made from an internal meeting, correct? Did the ministry communicate that decision prior to going to court to these respective players? Now, I do understand that for Augustus Prom, in the meeting that he was invited in, he would have been briefed,
yeah,
and he would be on standby. What about Parks and Wildlife, Gilma, and all the others that the Ministry of Justice had identified to be custodians of assets? Were they communicated to as a result of that meeting?
To the best of my recollection, no. And there was good reason for that. As I said, the application was going to be strictly confidential, and we didn't want to have that leaked to avoid people taking advantage to dissipate some of these assets, or to continue to dissipate some of these assets. And that is why I would have thought no one had communicated. It's certainly not under my instructions, and I believe they were not informed beforehand.
All right. So, to the best of your recollection, the personnel that were informed were perhaps the Registrar General and Augustus Prom?
Most likely, yes.
And then yourself and your Solicitor General?
And one or two members of the Civil Litigation Department.
Team. Okay. Now, when it came to the receiver, Augustus Prom, how was he identified, and how were they identified, and were they the only firm or persons considered?
So when we decided to use the Anti-Money Laundering Act, which provided for the possibility to appoint a receiver in the interim, I had another meeting with usually the same management team, the Solicitor General, one or two, perhaps 2 or 3 from the Department of Civil Litigation. And so we started to discuss who to entrust, which receiver to entrust these companies to. I recall at the time there were 2 or 3 names that were floated in this meeting. One of them was Augustus Prom, the other one was Alpha Barry. I'm struggling to remember the third who was mentioned. But in any event, amongst those who were mentioned, this small group, I was advised that Augustus Prom had prior experience dealing with government, because he was the one who was entrusted with the process of liquidating the Carnegie Company. I'm not sure if you are aware of the Carnegie Company, but there was a Australian mining company here that had a dispute with the government and which went into liquidation. So Augustus Prom was the one who was given that responsibility, and so he had an edge over the two orders, and I decided to go with Augustus Prom and requested the Civil Litigation Department to contact him for a meeting with us at the ministry.
All right. And just to answer your question, I do know about the Carnegie company. Thanks to records, I've read the cases. So as promised, Mr. Tambedou, we can now go to our beloved High Court order. But since we're at the order, and you and I both know that the order cannot come in vain, it needs to come behind a suit. Please guide this committee as to how the suit came, what the government was requesting in the suit, what was the claim?
You know, I want to believe that this is not a memory test. So if you have the application before you, kindly provide it to me. I can refresh my memory and tell you.
So I'm not speaking of the application just yet. I'm speaking of the writ.
But yes, but what about the writ?
We do not have the writ before us.
You don't have the writ from the High Court? Or
We
the
do
ministry?
not have the writ. However, if you could give us information as to what the claim of the government was before the courts. If you can remember. If you don't remember.
Oh, no, I certainly remember the crux of the application. I cannot forget these events.
Not the application. You know, before the application can be filed, a suit needs to be filed.
No, there was no suit here.
There was no suit.
You should look at the anti-money. Do you have a copy of the Anti-Money Laundering Act?
Yes, we do.
Can you share it with me, please?
You will be provided with a copy.
Please.
You wish to refer to it now?
Yes, if it is convenient for you.
Secretariat, please provide the witness with the anti-money laundering.
May I read you a provision of the Anti-Money Laundering Act, Section 51?
Please,
in particular,
proceed.
For the record. Section 51 of the Anti-Money Laundering Act, restraint of property. Subsection 1 reads, where a competent authority investigating a criminal conduct, a money laundering offense, or a financing of terrorism offense has reasonable grounds to believe that any money or property relating to the criminal conduct, money laundering offense, or financing of terrorism offense is held or is under the control of any person, the competent authority may apply to the court in accordance with subsection 2 for a restraint order prohibiting the person from disposing or otherwise dealing with that property except in such manner as may be specified in the order. So clearly, the provision is self-containing. There didn't need to be a suit precedent to the application for the freezing order. It was premised on this provision, and that's what we did. We submitted our application to the court under the provisions, and under exactly this provision.
And at the time of submitting that application, are you telling the committee that there was no suit before the court?
There was no substantive, there was no suit before the court, yes, in short.
All right. I would allow you liberty before I weigh in on my questions about the order. Please explain the genesis of the order and just a synopsis of what the order contains.
Well, after we received, as I said, the information from the FIU, we saw...
Would you like a copy of the order to facilitate your answer?
Not yet. I can provide the COX, and if you have further specific requests, I can look at that.
All right.
But
Perhaps
for now, I'll tell you.
In the meantime, I can ask the Secretariat to identify the order. That is MOJ 5A for the witness, Mr. Tambedou.
We considered, following the information from the Financial Intelligence Unit, which included information that were suspect, and which we thought established on a prima facie basis at face value some money laundering related offenses. And so we relied on those provisions and that information, and submitted an application to the court asking the court to freeze a list of bank accounts and properties that we attached to our application until the competent authority concludes their investigation. The competent authority in this case was the Attorney General, who was filing the application on behalf of the state in accordance with the State Proceedings Act. And so it's unfortunate, again, I'll come to that. We require a lot of civic education in this country. Many people, because it's the Attorney General who instituted this suit, they personalized it and made it my suit. But it was being done on behalf of the government. It was a government decision. And so we requested the court to freeze the assets that were attached to the list that accompanied the application until the competent authority, in this case the Attorney General, concluded his investigations.
So you approached the court and essentially got a court order. It was granted.
Indeed.
Now, after it was granted, to the best of your knowledge, were there meetings, or did you authorize meetings between the MOJ and all the stakeholders as it relates to the order?
I instructed my staff to convene meetings with all the stakeholders who had a role in the court order. Indeed, and that meeting was held, I believe.
Did your staff report to you the events of that meeting?
I recall receiving reports, yes, about the meeting.
Were they in the form of minutes or?
No, they were just oral briefings.
It was an oral briefing.
Yes, oral briefing.
Who determined which institutions would be included in the process?
It was after consultations within the ministry. Myself, the Solicitor General, members of the Civil Litigation Department.
What about Cabinet?
No, Cabinet did not participate in that process, as far as I recall.
So once the MOJ had gotten the order, and perhaps let me rephrase that, once the government of the Gambia had obtained an order from the court, because I guess you're alluding to the fact that the AG, or rather the Attorney General, acts on behalf of the government.
Certainly.
And since it's only the Attorney General's name there, you wanted to refer us to the State Proceedings Act to say that the Attorney General's name is there to act on behalf of the government.
Yes.
All right. Now, once we can agree that it's the government who obtained the order. Once the government had obtained the order, is it fair to say that the government was on notice?
Oh, absolutely.
The government knew that there was an order.
It was the government that requested the order.
Precisely.
Exactly. Yeah.
Now, from the perspective of a third party, the government was aware of the order. However, the committee has received evidence to say that elements within the government did not get wind of the order. And it begs the question, were institutions that would be included in the process given notice after the order was obtained?
That should have been done. Every stakeholder that had a role in the order ought to have been informed of this order, and I believe that was done.
Mr. Tambedou, would you be surprised if I tell you now that a chunk of offices did not get wind of the order?
Like which ones? Give me an example.
The committee has gotten evidence or has received evidence from the department responsible for livestock, stating that they were never in receipt of the order. At some point, they were communicated to by their parent ministry, which is the Ministry of Agriculture, and they responded to the letter for further instructions, which were not forthcoming. The ministry, rather the agency responsible for wildlife as well, did not receive the order, or did not get wind of the order.
May I?
Please.
Council, government functions in a particular way. Each ministry has departments under them. So Department of Wildlife, say for example, is under the Ministry of Environment is the line ministry. Department of Livestock, the Ministry of Agriculture is the line ministry. And so if communication is emanating from the ministry, from the Solicitor General, it would be addressed to the permanent secretaries of these ministries, who will then communicate the information to their departments. The Ministry of Justice cannot write directly to these departments unless, of course, as a follow-up subsequently over a matter that has already been initiated. But otherwise, as the first port of call, the ministry is the entry point for communications with departments under that ministry. And I would like to think that the Ministry of Justice would have written to the Ministry of Agriculture and Environment to inform them about this court order. I would be very surprised if we didn't do that.
Well, as far as this committee is concerned, I would wish to surprise you that that was not done.
What was not done?
No notice was given through any of the ministries that the committee knows of.
That the Ministry of Justice did not write to the Ministries of Agriculture and Environment?
Yes.
Well, perhaps the Solicitor General is in a better position to shed light on that. But having worked with him, based on my personal experience, I would like to believe that there was communications to those ministries. You know, Council, you'll be surprised also to learn that even within the Ministry of Justice itself, communications would come for the attention of the AG, and it would take a month before the AG sees it. That's just the way the civil service is. And again, I keep saying that's why the whole idea of civil service reform was to make sure that there is a more efficient service. But communications get lost, they fall through the cracks. I don't want to speculate as to what happened in this case, but I would be extremely surprised if that were the case.
Yes, and just to react to what you just stated, I would indeed be surprised if the AG would get correspondences a month later. In fact, I would be very disappointed. But I do get where you're driving at, though a month might be excessive.
I probably exaggerated a little,
yes,
but it will take a couple of weeks.
Yes. So my meager knowledge of the court process, the civil court process, is that once the court makes an order, it leaves it to the beneficiary of that order to facilitate service through the court, of course. I believe you have the same understanding.
In general, yes, in general.
And seeing that there were only two parties, the states and the former president, it would have been deemed by the court to be a done deal that the government was aware and would take control of the assets. Now, I'm not sure whether you had given a synopsis of the order as to what it contains. If perhaps let's let the record reflect what the order directed and to whom it directed to. Please take us through. Do you have a copy of the order?
Yes,
If it's not clear, is Is it readable? If it's not, then perhaps I can furnish you with a better copy.
You want me to read the whole order?
Not the whole order, but just take us through the main parts of the order and the main institutions or persons referred to in the order. So perhaps let me direct you to 2, 4, 5, and 8.
2, 4, 5, and 8.
Yes, those respective paragraphs.
Okay, paragraph 2.
Of course, paragraph 1 is important because it's expressly granting it.
It's the opening paragraph.
Yes.
All right, I'll start with that. Upon hearing, etc., blah, 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 accordingly it is ordered and directed pursuant to Section 51, subsection 3 of the Anti-Money Laundering Act, Anti-Money Laundering and Combating Terrorism Act 2012, as follows. 1. That the respondent be and an interim injunction is hereby granted, restraining him, his servants, agents, associates, or otherwise, howsoever, from disposing of or dealing with all movable and immovable properties held by or in the possession or control of the respondent, his agents, associates, and family members, as listed in the annexure marked 1, attached to this order, pending the conclusion of the investigation initiated by the Attorney General into the alleged criminal conduct of the respondent.
All right, let me suggest a different approach now. For 2, perhaps instead of reading it verbatim, just go through it for 30 seconds or so and just decipher out what asset and to whom it is for, to be, to whom it is to be bestowed upon.
Well, the order clearly says custody and control of all movable and immovable properties. And custody is granted to the Registrar General.
For all movable and
Immovable properties.
Yes.
Yes.
Just for the record, what would form part of movable and immovable properties?
Well, immovable properties are mostly landed properties, if you like, and movable properties are anything that moves, cattle, vehicles, I don't know, anything that moves.
That is not fixated.
Exactly.
Let's look at paragraph 4. Just for the record, paragraph 3 is further weighing in on what the Registrar General should be bestowed with.
Yeah.
Let's proceed to paragraph 4. You can look at it for a few seconds.
Okay.
Proceed.
Paragraph 4, of course, is with respect to the livestock, and this was entrusted to the custody and control of the Gambia Livestock Marketing Agency.
Yes. What about 5?
And 5, of course, is, as I said, the wildlife, and this is entrusted or was entrusted to the custody and control of the Gambia Wildlife Services.
All right. That's sufficient. And then the rest, there's also a portion that was supposed to be bestowed to Augustus Prom.
That's right.
All right, we're clear on that for now. Honorable Chair. Honorable Chair. Honorable Chair, I note that our usual time for break is about, but I'm suggesting that we go for another 10 minutes at least before we go on break, so that we go on break exactly at 2:30. If you are amenable to that. I'm grateful. So I was explaining that it is the applicant who would pursue the practicality of the order to ensure that all the tenets of the order are fulfilled. And the applicant here is the government of the Gambia, but precisely the Ministry of Justice, who are in conduct of the case. And here we are, about 2 institutions have not been communicated to. And you rightfully mentioned that the ministry did not have the expertise to preserve wildlife or domestic animals. But did the ministry have a mechanism to ensure that the court order got to its intended destination?
Well, that's why I said, I explained how government communications work, particularly interministerial communications. These departments are not standalone departments. They may be autonomous in their operations, but they have a line ministry, and there's a permanent secretary in that line ministry, just like there's a Solicitor General at the Ministry of Justice, and communications are typically between those officials, and then it will be up to those officials to further pass down the communications, the information. So I will not go as far as to say there was no communication with the departments. I can't say anything about that, but I would be very surprised if the Ministry of Justice did not write to the relevant ministries at that time to inform them or convey this order. I would be extremely surprised.
Now, what would you say if I would make a proposition that the government was pressed for time and there was pressure, and the Ministry of Justice, with their expertise, under your guidance, found an ingenious way of approaching the court, and that was through the Anti-Money Laundering Act. And I had mentioned earlier that usually applications like this come from the backdrop of a suit, a substantive suit. Now, this is not the norm. You found an area that would expedite and be more effective for the government. And you shot your shot, and it was granted. But when it came to communicating that decision, we fell back to protocol. What is ordinary? I would have thought that since there was urgency and pressure, that these orders would have reached their intended destination earlier than they did, if they did at all. So that would be to abrogate that protocol of writing to their main ministries, or their line ministries rather, or writing to their line ministries but copying them and sending a copy to them.
We did better than that.
Proceed.
They were called, I understand, to this meeting. So we reached out directly to them and invited them to a meeting. Again, to in line with your theory of acting expeditiously, we didn't just write. We called them as well and invited them to this meeting. As far as I recall, they were called and invited to the meeting, and they did come to the meeting at the ministry.
All right. Just two contentions on that statement. The first contention is that throughout the life of this committee, we have received evidence as to certain irregular communications, at least in the view of the committee. Now, the committee is aware that phone calls are a very effective way of communicating, but usually in public administration, phone calls are deployed for follow-ups and not for the initial contact. Now, it's that initial contact that I am interested in. That's my first contention, that the phone call perhaps was not the most appropriate way to communicate the order to them. But perhaps what you're saying is that the phone call was to invite them for a meeting, and then in that meeting they will be made known of the order. You can clarify once you have the floor. But my second contention is that we received evidence that they were not in the meeting. None of them. That is the Department of Wildlife. I don't believe it's actually called the Department of Wildlife, but for ease of convenience, let's refer to it as Wildlife. Wildlife was not part of those institutions in that meeting. And Gilma, which is the Gambia Marketing Livestock Agency, was also not part of that meeting.
Okay.
Would you be surprised to note that?
Yes, indeed. And for the simple reason that I would have expected Ministry of Justice staff to be able to convene. In so far as I recall, that was the briefing, that they were going to be invited to a meeting to be informed of this order. But let me go back to your first point of contention about the so-called irregular communications. You know, I will have to go back to context here because it's important for all of us to be on the same page. You know, Council, the freezing order was obtained in May, the first one, May 2017. I believe the president returned to the country in February. Correct me if I am wrong. I can't remember, but I believe it was in February. I certainly came in February, got sworn in, went back, came back in March, April, May. When I came back to the ministry, after not having worked at the Justice Ministry since 2000, almost 2 decades after, I found the ministry with the same modus operandi as I left it 20 years earlier. In other words, to even get a letter typed out, there were a pool of typists, maybe 2 or 3 who were at the criminal division and maybe 1 or 2 at the civil division, and state lawyers were writing their legal opinions, their letters, their correspondence with pen and paper. And then each of them would submit those handwritten opinion and legal advice to the pool of typists, who will take turns to look at each file, each assignment, to type it out and give it back to the State Council to review, etc. This is how mechanical and tedious it was. This is what I found at the ministry at that time, that it would take days, if you want, for even a simple letter to be typewritten and be sent out. And that's why we resorted to making phone calls. So it may be irregular to you today, and it may even be irregular to the ministry today, now that every state lawyer had a desktop in their offices. But at least when I was leaving, I managed to get that for them. But at the time, no state lawyer had a desktop in their offices. Some who had computers were using their personal laptops. And it was the pool typing system that we had. So if we were to wait for the secretaries to type these letters so that we can send them, that would take days. And these orders needed to be implemented immediately, urgently at that time. So you can see we didn't have the luxury of time, of the time that you have now, and label those communications irregular. It was, I keep saying, the best we could do at the time, given the resources and the environment. So, but if the second contention is that members of the Department of Livestock and Forestry, Wildlife, were not in that meeting, I would be shocked. I would be surprised. But again, like I said, the instructions as far as I was concerned and the feedback as far as I could recall was that they were meeting. It was called the implementation meeting, if I remember correctly. It was a meeting to discuss how to implement the court order. So I am very surprised that those who were given a role in the order, did not participate in any meeting at the ministry. I am very surprised about that.
All right. What about the instructions? How were they communicated to the team that were supposed to enforce the order? Were they also verbal instructions?
There was a lot of verbal instructions at the time, particularly when they are not contentious issues. Yes, I mean, the ordinary course of your work, you give verbal instructions. That was quite common. As I said, if not for anything else, but for the fact that it would take an inordinate amount of time to be typing out these, type out instructions to staff within the ministry.
Of course. All right, I believe this is a convenient point to stop, Honorable Chair. For want of being crucified by the Sisekundas, I would stop here and resume after the break.
Thank you so much, Council. Yes, very well. I think it's a convenient point for us to take a break for our usual prayers and lunch. Remember, there is always prayers before lunch. Eh? That's for the Turekundas as well. Thank you. So we will come back at 3:30, at least 1 hour, so we can proceed with the testimony again. Thank you. Meeting adjourned for now. Thank you.